Today, we're diving into a massive question. For anyone building with AI, how do you actually protect the stuff you create? Think of this as your essential guide to intellectual property in this brand new world. Okay, so picture this. You've just used an AI to design a killer logo, write some brilliant code, or maybe generate a stunning piece of art. It feels like it's yours, right? I mean, you made it happen. But in the eyes of the law, well, the answer to who owns it is a whole lot more complicated. So let's break this all down. We're going to arm you with the legal toolkit you need to navigate this tricky new landscape and make sure the work you do stays your work. First things first, we need to understand our basic defenses. I want you to think of these as your 3 IP shields: copyright, trademark, and patent. So what is intellectual property, or IP? At its core, it's all about the things we create with our minds. It's the legal right that says, hey, I made this and I get to control it. And here's how those 3 shields work. Copyright? That's for original creative stuff, like the source code for your app. A trademark protects your brand, the name and logo that screams, this is mine. And a patent, that's for a truly new invention, like a totally unique AI algorithm. See? Each one protects something very different. But this is where things get really, really tricky for AI creators. You're about to run into the single biggest legal hurdle there is, something called the human authorship rule. So here's the heart of the problem. Our laws were basically built to reward human creativity, and the law is crystal clear on this. To get a copyright, a human being has to be the author, and AI, as far as the law is concerned, can't be an author. So what does this actually mean for you? Well, if you just type a simple prompt into an AI and use whatever it spits out, that work is probably going to be in the public domain. Anyone can use it, but here's the game changer. If you use AI as a creative partner, you generate a bunch of elements, but then you do the heavy lifting of editing, arranging, and combining it all into a final piece, that might be copyrightable. Why? Because your creative input, your human touch, is the secret ingredient. The more of you in the final work, the stronger your claim. Okay, so if copyright is a minefield, how do you protect the real heart of your project? Your unique algorithm, your secret sauce? This brings us to a huge decision: patents versus trade secrets. Let's say your algorithm is an absolute game changer. Can you patent it? Well, just like with copyright, patent law has a human inventor rule. You, the person, have to be the one who came up with the invention. But even if you can clear that hurdle, is a patent even the right move for you? And this is where the powerful idea of a trade secret comes into play. A trade secret is any confidential info that gives you an edge, and you protect it simply by keeping it a secret. It's the Coca-Cola formula approach. For you, this could be your source code or your custom training data. The protection comes from you guarding it. So here's the choice you have to make. To get a patent, you have to publicly reveal exactly how your invention works, and that protection only lasts for a limited time. It's also really expensive and slow. A trade secret, on the other hand, can last forever as long as you keep it quiet, and it doesn't cost anything to register. The big catch? A trade secret doesn't protect you if someone else invents the same thing on their own. You've got to decide which risk you're more comfortable with. Okay, let's switch gears and talk about working with other people. It doesn't matter if you're hiring a freelancer or partnering with a designer, you have to remember one thing: contracts are your absolute best friend. Seriously. And this is a massive trap, one that so many creators fall right into. By default, an independent contractor owns the copyright to the work they create for you. Just let that sink in for a second. The code they write for your app might legally belong to them, not you, unless you have a very specific agreement. So how do you fix this? It's a simple 3-step process. 1. Always get it in writing. 2. Your contract must have something called an IP assignment clause. This is the magic little piece of text that legally transfers ownership from them to you. And 3, have them sign a non-disclosure agreement, an NDA, to protect all that secret sauce we were just talking about. And this is the kind of legal language you're looking for. See how it leaves no room for doubt? It makes it perfectly clear that anything the contractor makes for the project becomes the sole and exclusive property of the company. If you want to own your project, this is completely non-negotiable. All right, for our last section, let's zoom out a bit. Your creation is probably on the internet, which means it's global from day one, and that requires some smart, strategic thinking. Here's a super important principle to remember. IP rights are territorial. That means registering a trademark in the US does absolutely nothing to stop someone from using that same exact name in Germany or Japan. If you've got a global audience, you need a global strategy. So let's wrap this all up with your action plan. Number 1, read the terms of service of any AI tool you use. You have to know who owns the output. 2, before you fall in love with a brand name, do a search to make sure it's actually available. 3, get every single collaboration in writing with those key clauses. 4, you don't have to file everywhere at once. Prioritize the international markets that matter most. And finally, remember, this is just a guide to get you thinking. Always, always talk to an actual lawyer for real legal advice. And that brings us to our final thought for today. We're living in this incredible moment where AI is shifting from being just a tool to becoming a true creative partner. The laws we have now, they were written for a totally different world. So the really big question we're all left with is this: are our current laws going to be enough, or are we going to have to fundamentally rethink what words like author and inventor even mean in the age of AI?